Hello, good morning everybody and welcome to our GDPR for your payroll bureau this morning. My name is Laura Murphy and I'm joined today by my colleague Jennifer Hussey and we'll take you through the legislation. We are recording this morning's session, so we will send you a recording with some extra slides and extra notes later on this afternoon. And we will, as always, we're delighted to take your questions. We're going to keep the FAQs till the end, and we find in this webinar that can go on quite a while as well. We had some interesting questions, which is great. But if you think of questions as we go, please do type them in and then we'll just get to them at the end. And I think that's all. I'm just looking over. I think everything's okay on the sound. Hopefully you can all hear us loud and clear. So without further ado, we'll get going. So GDPR, it's certainly the buzz term at the moment, and again, certainly for good reason. The scope and the impact of how the GDPR is going to impact on businesses, it cannot be overstated, and it will affect most, if not all, areas of your business as well, and change how you manage personal data. So we've broken the webinar today into 4 sections. We'll do a very quick overview at the start, then we look at the key changes to the data protection legislation, and then we'll focus on how you can prepare your payroll bureau, and we'll take a little look then at how BrightPay is preparing as well. Okay, so first and foremost, what is GDPR? GDPR stands for General Data Protection Regulation. The GDPR is a European privacy regulation replacing all existing data protection regulations right across Europe. So it's an extremely significant piece of legislation, and it will change, as I said, how we manage our personal data. The primary principle underpinning the GDPR being to make data protection rules fit for purpose, taking account of the vast technology developments over the past 2 decades. These changes in technology also extend to how organisations collect and store their personal data. The current UK data protection legislation dates back to 1998. And this really predates the current levels of internet usage and how we use apps and etc. and technology today. So, it really is unsuitable for the digital economy. So definitely an update was needed. That's not to say it doesn't cause some extra challenges for those of you and those of us who do process data. GDPR really puts the onus on businesses now to change their ethos in relation to data protection with a clear message of continuity. So preparation for GDPR is really key, but that's not the end of it. It's not just a tick box exercise, right, we're done. It needs to be kind of become part of your business processes, and we'll talk about that in more detail. So I suppose previously data might have been seen as an asset if you had great mailing lists, etc. Now we're looking at it as a liability.
Yeah, so as Laura mentioned there, the D-Day for GDPR is the 25th of May this year. So this is the day the legislation comes into force. It's vital to remember that this is the day you actually must be compliant by. And at this stage, we just have over 3 months to go. So if you haven't started to prepare, now is the time to do it. Don't leave it until the 25th of May to start preparing, because at that stage, you're going to be in the bad books. So reasons why you need to pay attention. Okay, and these are quite big reasons. So organisations can be fined up to 4% of their annual global turnover for breaching GDPR, or 20 million euro, whichever is the higher. Now this is the maximum fine that can be imposed for the most serious infringements, like not having sufficient customer consent to process data, or violating the core privacy by design concepts, and we'll look at those a little further on. There is a tiered approach to the fine. So for example, a company can be fined 2% for not having the records in order, not notifying the supervising authority and or the data subject about a breach, or the likes of not conducting impact assessments. It's important to note here that these rules apply to both controllers and processors. So you as payroll bureaus, i.e. processors, could also be liable for these fines as well. So other than that, other factors you obviously have to take into consideration there would be likes of brand damage, loss of business, the cost of investigation, litigation, things like that, other than the fines.
Yeah, and there's all sorts of online research out there that says X% and 50% of small businesses with less than 50 employees would close if they had a fine. I think that the percentage is much higher. I don't know, many small businesses could survive if they got a 20 million euro fine. Now that said, we don't want to overly scare you, because it is believed that the fines under the GDPR will be proportionate, and they may not even be issued in the case of every infringement, taking into account any other mitigating circumstances and plans, etc., that you had in place. But we need to tell you about the fines, and of course it's advisable that you don't want to run the risk of the fines. The other area that is kind of a risk or a concern will be civil liability. Individuals can now take data controllers and processors to court to claim compensation for material loss and non-material damage. So this means compensation for distress, hurt feelings, reputational damage, even if there is no proven financial loss. So if you have a GDPR breach on top of the very substantial fines that we've just talked about, you could face a civil case as well.
And just in relation to that, we actually saw there in December the very first data protection class action case in the UK with the supermarket chain Morrison's. The High Court found them to be vicariously liable for the actions of a disgruntled employee who actually stole information relating to 100,000 employees. He then went on to release their bank details, salary information and other identifying information via data sharing websites and newspapers. Now out of that 100,000, 5,500 employees have brought a claim against the supermarket for allowing their data to be stolen. Now, these haven't been settled yet. That's going to come up in the next couple of months, but this really is a landmark case in privacy law. So after May, there may be a noticeable increase in the class action cases for data protection breaches, because civil liability with the GDPR is going to be coming into force, as well as the fines.
Perfect. So again, briefly, as most of you all know, the supervising authority in the UK is the Information Commissioner's Office, the ICO. There will also now be a European Data Protection Board, which among other things will adjudicate on disputes, and they'll oversee the individual member states, their bodies as well. I have to say that the ICO have excellent resources in place to assist bodies getting ready for GDPR, and particularly for small businesses, whether that be even for yourselves or your clients. They actually also have a new helpline specifically for small organisations, and that went live back in November. We've rang it a couple of times. I have to say I found them very helpful if you have a query or a question, and it is an excellent resource. So, do use it is there. A question that's come up to us as well in the past is the requirement to register with the ICO. Whilst there's no requirement to register for GDPR, however, there is a provision in the Digital Economy Act which means that it will still remain a legal requirement for data controllers or companies like yourselves to pay the ICO data protection fee, and it's just a registration process. You're familiar with it online. I think for most small employers it's about £35, so you will still need to do that.
So moving on then, who does it apply to? And again, this is a question that we get quite often. So the GDPR affects EU companies that process personal data, regardless of whether the processing takes place in the EU or not. It applies to non-EU companies who offer goods or services to individuals within the EU, irrespective of whether payment is required for those services. So we're looking at the likes of your Facebook, things like that. It also applies to non-EU companies who monitor individuals' behaviour that take place within the EU, so Google, Yahoo, places like that. So really we can see it's not just European countries or companies that are going to be affected by the GDPR, it's really going to have a knock-on effect globally.
Yeah, and just very, very briefly, just to mention Brexit here, the GDPR comes in obviously on the 25th of May this year, and of course the UK will not have departed the EU at that stage, so the GDPR will apply in the UK from the 25th of May, and certainly all signs suggest towards that once the UK does leave the EU, we will have similar legislation. There was the Queen's speech back in June, and she even made reference to the general data protection and the new directives coming in. And then in the post-Brexit era, she said that the UK wants to be in the best position to maintain our ability to share data with other EU member states and internationally after we leave the EU. So it's just kind of further confirmation that the UK will implement a UK bill post-Brexit which reflects the GDPR framework. So certainly Brexit is not a reason to ignore GDPR legislation. Before we go any further, I just want to clarify some key terms, and we've already used data controller, data processor as we're talking, so I just want to clarify them before we go any further to fully kind of just say what they are. So the data subject is an individual who is the subject of personal data. For yourselves as maybe employers, as some of you may would be your employees or your customers' data. They're the data subjects. Data controller controls the content of the use of personal data. So if you are a payroll bureau, the data controller will be your client because they kind of control the personal data, and then in turn you are processing the data. So you are a data processor. And processor means a person or public authority, agency or any other body which processes personal data on behalf of a controller. Processing means any operation which is performed on that personal data. So that could be anything from just recording it, from storing the data. So you don't actually have to be working on it, even storing data would clarify as processing. And then a personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, unauthorized access, anything like that, or data being stored and processed in a way that it was not intended to. And we'll come back to breaches in more detail as well. So that's just a very quick definition overview. So we want to go on now to look at the key changes in the data protection law. So what's different from the existing data protection now as we come into the GDPR era? We've kind of highlighted 10 key differences that are made in the GDPR. So we'd like to go through each one of these 10 points now. The first one is personal data. So I can imagine at this stage you're saying to yourself, well, what exactly is personal data? And the definition is any information related to a natural person or data subject that can be used directly or indirectly to identify that person. So this list it's not an exhaustive list by any manner or means, but certainly some new things have been added, such as the computer IP address. That wouldn't be in the existing legislation, but it's in GDPR. So certainly I would imagine, you know, you're holding this kind of information as a payroll bureau. You've bank details, you've people's names, you've got their NI numbers. So you certainly are processing personal data. But I suppose just to look into that a little bit more detail, in the working life of an accountant or payroll bureau, it does involve daily interaction with vast amounts of personal data, including data on your clients, data that you hold for marketing purposes, and again, data that you might hold on your employees. So in handling such data, it goes without saying that you've always had a responsibility to keep that information secure and to ensure that individuals' rights are respected. The GDPR doesn't change that at all. If anything, it places now more onus on you to handle information correctly for the businesses that you work with, and that includes keeping the data secure by protecting it from cyber attack, which again is an increasing from a range of things, protecting from a range of things, including cyber attack, I suppose I should say. And again, we'll come back to that.
Another area that we want to look at then is your special categories of data. So this would be the likes of sensitive personal data or sensitive data which is extended by the GDPR. So they've added the likes of genetic and biometric data to this protected category. So under this expanded definition, the specially protected categories extend to the processing of racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, and the processing of genetic data, biometric data for the purpose of uniquely identifying a person, data concerning health, data concerning a natural person's sex life or their sexual orientation. So just in regard to those special categories, more onerous conditions must be satisfied in order to legitimise the processing of that data. And, you know, in particular, you need the explicit consent of individuals if you plan on processing any of that information that we've just looked at.
Yeah, and just a quick note here, the processing of biometric data brings up an interesting point in relation to those employers who require employees to clock in or clock out using their fingerprint or handprint. Finger or handprints will be considered as biometric data. So unless as an employer you can make a legitimate argument that is that you are processing biometric data for the vital interests of an employee, or in doing so in the public interest, you might find it hard to legitimately continue to record that data. You know, it's not something that's specifically going to relate to your payroll bureau, but it's just a kind of a one worth noting.
Absolutely. It was actually something that came up as a question from a customer of ours. Now, I believe they owned a restaurant or a coffee shop and actually used biometric data as like a clock-in system. And realistically, for those purposes, it wouldn't be deemed to be appropriate to keep that.
Yeah,
clock-in.
or for it to be the only option. Certainly you could have it there, but the option for an employees to opt out if they wanted to. Now, the GDPR allows member states to make their own different kind of derogations from the legislation. So it could be that the UK decide to make a change in that. We haven't seen any yet. So, you know, we wait and see. But it is, as I said, it mightn't affect you personally or in your businesses, but it might be something that might affect your clients. And we'll talk about your kind of maybe your role in advising clients as well a little later.
And just one final point there on the special categories. The processing of photographs will not automatically be considered as processing of biometric data. However, photographs will be covered where they allow the unique identification or authentication of an individual as a biometric. So for example, if they're used as part of the likes of your electronic passports, or, you know, your kind of your social welfare for the purposes of facial recognition.
Yeah, anything that is used for facial recognition. Perfect.
So currently under the data protection legislation, we have 8 principles of data protection. Now this has been reduced to 6, but certainly none of that content has been lost. If anything, it's been bulked up. So under the GDPR, personal data shall be processed lawfully, fairly, and in a transparent manner. It should be collected for specified, explicit and legitimate purposes only and not further processed in a manner that is incompatible with those purposes. It shall be adequate, relevant and limited to what is necessary in relation to the purposes for which they are processed. It needs to be accurate and where necessary kept up to date. Every reasonable step must be taken to ensure that personal data that's inaccurate is erased or rectified without delay. The personal data needs to be kept in a form which permits identification of data subjects for no longer than what is necessary. And it needs to be processed in a manner that ensures appropriate security of personal data. So including protection against unauthorized or unlawful processing, against accidental loss, destruction or damage. And by doing that, use appropriate technical or organizational measures. The overarching kind of principle here is that of accountability. You really need to be able to demonstrate compliance with these principles. You know, so really, therefore, there's an increased burden of proof on the processors, the controllers in this regard. And we've kind of spoken to a number of different bodies in relation to this, and it is our opinion that if your company is meeting your obligations under the current legislation, then really the compliance with the GDPR shouldn't be too onerous, and it shouldn't be too much of a change. So again, you know, nobody's trying to scaremonger.
Yeah, it's probably the biggest thing is maybe documenting what you already have in place so that you can tick that accountability box. But we'll move on.
Okay, so we look now at the reasons why you can process data. Okay, so processing data is only deemed lawful if the data subject has given consent. And we'll come back to the issue of consent now in a little minute. It's only lawful if it's necessary for the performance of a contract or to take steps prior to entering into a contract. So for example, if your employment or your payroll contract with the individuals. It's only lawful if it's necessary for the compliance with legal obligation to which the controller is subject. So for example, your tax records, things like that. It's lawful if it's in order to protect the vital interests of a person, if it's necessary for public interest or official authority. So that's kind of more or less going to be with the likes of public sector bodies. And only lawful then if for the legitimate interests of a data controller or yourself, the employer in this case. And this is really where you can have a little bit more flexibility in kind of classifying your processing. So for the likes of having your coding notices or attachment orders, you need to, you know, kind of hold on to them in order to maintain service levels and details for, you know, your up-to-date tax information if you've audits or things like that. So when you are reviewing the data that you process and asking yourself, why is it lawful? Is it lawful for us to process this data? Then these are the points that you need to be looking at to get that first step going.
Yes, this is an important slide here. Perfect. So Jenny mentioned consent there, so I'm just going to touch on consent. If you are relying on consent in order to process data, you need to be aware that there now is an elevated threshold for consent. So firstly, consent must be specific, informed, unambiguous and freely given. And you must have evidence or be able to show proof that clear affirmative action has been given, and it must be for a specified purpose. Where consent is obtained as part of a larger document covering other things, consent text must be clearly distinguished from everything else. So really you can't hide your consent in your big T's and C's in a big document. It's nearly recommended that you would have that separate. And when we're talking about consent, actually, just to go off slightly, in terms of the Payroll Bureau, you're not going to need to rely on consent from your data controllers or from your clients in relation to carrying out the payroll and providing your service, because you're going to be relying on the other points that Jenny talked about, fulfilling a contract, etc. For the most part, I would imagine you'll be relying on consent for marketing purposes. If you have marketing emails, if you're sending out marketing newsletters on a monthly basis, that kind of thing. You may also be looking at consent if you're having some of the special categories of data that Jenny referred to as well. So that's where consent would come in for yourselves. So just moving then on to my third point here, evidence needs to be retained. So we mentioned that as to how the consent was obtained. For example, whether that's a form, a brochure, signage, and website screenshots, and the language. This is really important and a point that's made several times in the legislation. If you're asking for consent, it has to be in an easily understood language. No more legalese, particularly when you're obtaining consent for those under 16. But just kind of to go back to the consent must be specific and informed, and we've all clicked on signing up to newsletters, etc., when you're purchasing something online. And sometimes before you hit go or hit yes, you might see that a tick box to the terms and conditions, and the tick is already in there. It's pre-populated for you, so you don't have to do anything. That would be inappropriate under the regulations. You need to have somebody actually have that affirmative action. The action needs to be done by the individual that you're taking the information from. So that's the consent side of it. As I said, for the Payroll Bureau, you're more talking about for your marketing material. Another key change that the GDPR brings, that's going to be particularly specific to yourselves as accountants and payroll bureaus, is changes in the rules for data processors. So processing personal data on behalf of another business. We've already said that. So again, that's you as the payroll bureau. You are a data processor for your client. So there's now increased responsibilities here. So you'll have more direct compliance responsibilities than under the current law. I've highlighted some of the key changes here. So the first one, controller instructions. As a data processors appointed by a controller must provide sufficient guarantees to implement appropriate technical and organizational measures, we'll touch on them a little bit more later on, to ensure processing meets the requirements of GDPR. So if a client has appointed you, you need to be able to prove that you're meeting GDPR or taking all sufficient steps, I suppose. Restrictions on subcontracting, again, another important point here. Data processors now require prior written consent from the controller to subcontract their activities. The processor is required to inform the controller of any new sub-processors, allowing the controller to object. The lead processor is required to reflect the main contractual responsibilities in its sub-processing agreements and remain liable to the controller for the action or inaction of the sub-processor. And a contract. Again, I'm going to talk about this in more detail, but the contract between you and your client is going to be very important. Data processing activities must be governed by a contract. So, and that's already in legislation, but what is kind of changed here, I suppose, is that there's now extra information that you need to put in those contracts. And again, we'll touch on that in more detail, but I suppose the main point to make on this slide is that as a data processor in a payroll bureau, you will have increased responsibilities that you'll need to address, I suppose. Okay, security, a big issue. And given the potential significant impact of security breaches, data security is addressed significantly under the GDPR. The GDPR contains both preventative and reactive requirements in respect of personal data breaches. So in terms of the reactive measures, the GDPR introduces a duty on organisations to report breaches to the relevant supervisory authority, so in our case the ICO, and in some cases also to the individuals affected. So a security data breach, it's very widely interpreted, and generally a breach would mean a breach of security leading to the destruction, loss, alteration, unauthorised disclosure of or access to personal data. So it's much more than just losing personal data. You know, to give an example of a hospital that could lose they could lose their health records, and there's actually loads of cases. We were reading some cases on data breaches that are quite interesting. So there's loads of examples of how it might happen, and it can happen. You know, it can happen. It can be human error as well. But in the case of a data breach, and in reporting it, it must be reported to the ICO only, however, not in all cases. Not all cases of breaches have to be reported. Only where the breach is likely to result in a risk to the rights and the freedoms of the individual. For example, result in discrimination, damage to reputation, financial loss, loss of confidentiality, or some other significant economic or social disadvantage. And really this has to be assessed on a case-by-case basis, and you'll need to appoint somebody in your company that will make that final decision as to whether a breach results in this risk to the individual and whether it should be reported. In terms of when you need to report a breach to the individual themselves, breaches that are likely to result in a high risk to the rights and the freedoms of the individual must be reported to the individual concerned. So we see the difference is only the high risk. So it's a risk for the ICO, but a high risk when we're talking about reporting it to the individuals. So the high risk means that just the threshold for notifying individuals is higher than for notifying the relevant supervisory authority. And you do have 72 hours from the point of becoming aware of the breach to report that breach. Failure to report a breach within the required time frame could also result in a fine as well. So on top of all those other fines that we've talked about, you could be looking at a breach for missing your 72-hour deadline. So in terms of preparing for this, you need to ensure that your staff understand what could possibly constitute a data breach in your business, and that you have internal data breach and report systems in place so that if somebody becomes aware of it, they know who to go to and who to talk to. And it should be predetermined as to who will make that final call as to whether you go to the ICO or you need to notify the data subjects. And you need to at all times be aware of the data that you store in your organization so that you can have these protocols in place. Secondly, when we talk about security, we talk about the preventative measures. So you should have technical and organizational preventative measures in place that will A, help prevent a breach from happening, and B, minimize the impact of that breach. So we'll talk more about those technical measures and the organized measures and what they might be in your company a little later on as well. But these are just the changes that have been outlined in the legislation.
Perfect. So Laura just spoke there in relation to the security as to having somebody in place who you will appoint for, you know, breaches and who you need to go to if there is any issues. So the Data Protection Officer, the DPO, is a new role that is going to come into effect with the GDPR coming into force. And the main role of the DPO will be to monitor internal compliance with those new regulations. It will be mandatory to appoint a DPO for the likes of your public bodies, organisations engaged in large-scale systematic monitoring. Who would that be now?
Public sector bodies, or maybe health insurance?
Yeah, okay. Organisations who have core activities that consist of processing special categories of data or data relating to criminal convictions. So that'll obviously be the Metropolitan Police, I imagine. It may also be mandatory in other contexts. But as Laura stated earlier on, this can be defined by the member state themselves once GDPR has actually come into effect. Just in relation to that, with the DPO, they mustn't have any internal conflict of interests. So whoever you appoint really shouldn't be the likes of the HR, the financial manager. They need to be sufficiently senior so that they can implement obligations, and obviously they're going to be reporting to the highest level of management. It doesn't have to be an employee, and it seems to be quite common that the DPO could be outsourced.
Yeah, it's a kind of a trend that we seem to be seeing, that it could be outsourced.
Yeah, companies popping up all over the place now. And if you have a group of organisations that are kind of in different areas, you might have one office in London, you could have another one in Newcastle. A group of organisations can have just the one data protection officer as well.
I'd hate to make a sweeping statement here, and certainly, don't take my word for it, but our understanding is, for the most part, your day-to-day payroll bureau, small accountancy practice would not need a DPO. That said, it's certainly worthwhile just being able to document your consideration on this and show that you've considered it and that you feel you don't or you do, either way. Okay. Individuals or data subjects now have new and enhanced rights under the GDPR. So there's quite a list. So we're going to kind of take turns and going through them. But to start off, the right to be informed. This emphasises the need for transparency in how you use personal data. You must be very clear with data subjects on how their data is used. So this is really in relation to your privacy policies. And again, we'll touch on privacy policies later on.
Perfect. The next one then is the right of access. So this is where the data subject is requesting access to the data you hold on them. And there's a couple of points on that. So the time frame for the response to the request was originally 40 days. This has been reduced down to 1 month. And bear in mind, if the request is made electronically, i.e. via email, let's say, then you need to provide the information in an electronic format back. So reply to the email and you have a record of it. With the GDPR, the fees have been removed in relation to the access request. So currently companies can charge £10 to the data subject for giving that access or that data information. But under the GDPR, there will be no charge. A question that we've had before is, if a data subject of your client, so let's say one of your client's employees wants to put in a request to access their data, can they go directly to you, the payroll bureau, the data processor? Our understanding is no, that if an employee of your client should go directly to their client, to their employer, your client, and request the data from them, and then in turn you might get a request from your client, which you don't necessarily have to receive a request directly in from that employee. Absolutely. And then the final point on that in relation to the right of access is that the data processor can refuse the request if it is found to be, kind of manifestly excessive.
Yeah, and if it is manifestly unfounded or excessive, you can put a charge in as well, but again, you'd have to be able to prove that and be confident that it was there. There's also the right to rectification. Individuals are entitled to have personal data rectified if it is inaccurate or incomplete. This is an existing right. There's an enhanced right with regard to the right to erasure, also known as the right to be forgotten. The broad principle being that an individual has the right to request deletion or removal of personal data only, and this is the important part, only where there is no compelling reason to retain the data. Obviously, you will have legal reasons why you need to retain some payroll data for the X amount of period in terms of HMRC, so you wouldn't delete anything there. So the law will always override any request from the employee or for the data subject, but where there is no other reason, they would have the right to have erasure. The right of erasure and the erasure of data could potentially be difficult in a payroll bureau accountancy practice situation due to the amount of backups, or if you're using different systems and multiple systems and different cloud storage. So you'll need to be aware of exactly where your information is and that you're deleting it off all systems, really.
The next one then is the right to restrict processing. In this regard, similar to what Laura's just said, you would still have the ability to retain the data for whatever period you're required to, but the right to be able to restrict what you actually process is there. The right to data portability. So this allows individuals to move, copy or transfer personal data from one IT environment to another once it's in a safe and secure way. And this is commonly done in the likes of the banking industry.
We'll probably see it being done more and more as people do more and more activities online. As well. So then we have the right to object to the processing of their data, for example, for direct marketing purposes. So when we were talking earlier about, you need to have that affirmative act in to tick, yes, please include me in your mail letters, etc. You also need to make it clear to individuals at that stage that they can opt out at any time as well, and that can be done, and you would put that in your privacy notices as well. And then finally, rights in relation to automated decision-making. Automated decision-making relates to any form of automated processing intended to evaluate certain personal aspects of an individual. This would include their health, their work. It's used a lot in recruitment more and more now when you're doing, we're talking about AI, automatic intelligence. So where any kind of automated decision-making exists, individuals have the right to obtain human intervention. They have the right to express their own point of view and obtain an explanation of the decision and the challenge. So if people are going to a bank, and they're applying for a loan, if that loan was purely made on an automatic decision method, they could decide otherwise. Obviously, we're talking about your payroll bureau and the rights of your clients, but just to point out very briefly here that if you do have employees and staff, all the rights that we've talked about here, they'll apply to your employees as well. And the GDPR, just on the employee aspect of it, the GDPR introduces a recommendation. It's not legislation, but it is a recommendation that where possible, when you're dealing with your employees, organizations should be able to provide remote access to a secure self-service system, which would provide individuals with direct access to his or her information. So rather than an employee wanting to know what's held on them, what documents you hold on them in their HR file, that they would have a self-service system where they can see all that information for them, similar to the BrightPay cloud, if you're familiar with it, or BrightPay Connect, should I say. So again, that's not going to work in all businesses and mightn't work for you or your clients, but the recommendation is there as well. And that's all coming from this idea of transparency.
So then other concepts that are coming into effect. We look at now the privacy by design and privacy by default. These are important new concepts under the GDPR. So the privacy by design requires organizations to consider privacy measures during the product design processes, while the privacy by default requires controllers to ensure that by default only necessary data is processed. So what we're looking at here is that your privacy or the consideration of privacy is embedded into the DNA of an organization. The GDPR requires formal data protection impact assessment, so PIAs, in relation to higher risk processing activities. So as a data controller, if you propose to carry out new processing activities, if that processing will result in high risk to the individuals, you will be required to conduct a protection impact assessment. The likes of high risk processing might include processing on a large scale of special categories of sensitive data that we looked at earlier on, or of personal data relating to criminal convictions and offences. Or it could be the likes of large-scale systematic monitoring of a public area. So the regulations are going to provide guidance on just exactly what needs to be included in the likes of these. But just bear those in mind. What they're looking at really is that you're implementing, you're considering the privacy, the data protection from the get-go, really.
It's almost as if, if you're at a meeting and you have a marketing section, you have a finance section, you have your HR section, and now really we should be putting in a data privacy section to our meetings, or including if we're implementing a new process of how we'll do something in our company, we must consider the data protection implications as well as the finance implications, etc., etc. So it's about embedding it, as Jenny said. Brilliant. So that brings us to, we've gone through our 10 steps there of the key changes, and that brings us along to how to prepare your payroll bureau. So we've created a 7-step guide that we feel businesses should consider when trying to kind of set up their preparation and plan for GDPR. We're going to look into each one of these in more detail, but just really to give you a brief summary, I suppose. The first step, and really a really important step, is to complete an inventory of all data held and processed. This will be a big step in helping your practice become accountable, and we all know that that's one of the key concepts now, GDPR. The next step, you'll need to review your existing privacy policies and update where necessary. The contracts here refers to your contracts you have in place with third parties and probably more importantly for yourselves with your clients. And we'll talk about capturing consent. If you are relying on consent as a legitimate reason for processing data, you need to step back, you need to take a look at how you are getting that consent and is it compatible with GDPR. Governance. So this is the ongoing maintenance of GDPR compliance. How are you going to plan to ensure that? As we said right back at the start, it's not a tick box exercise. It's going to be part of your business from now on. Security, we talked about the technical and the organizational measures. What might they be in your payroll bureau? Your privacy impact assessments and your data by design that Jenny just spoke about. You want to just look at where you may need to address this in your organization. And the final one is perhaps maybe not something that you need to do, but it's maybe something that we would recommend. As a payroll bureau or as an accountancy practice, I'm sure you all know that you're often a source of advice to your clients on a range of subjects. So we're recommending that you play some form of a role in informing and advising your clients on GDPR as well. So that's kind of a brief overview, but let's just kind of kick off then and look at the data inventory.
Perfect. So as Laura said, this is quite a big one. And as a first step, you should review all the personal data that you hold. So whether that data relates to current or former clients, employees, unsuccessful job applicants, or other third parties that you may have come into contact with. This can be referred to as completing a data inventory or data mapping. So it is recommended to record all data held under the following headings. So why are you holding that data? What is the legal basis for it? How did you obtain the data? Did the data subject know they were providing the data to you? Why was it originally gathered? How long it was held for? And remembering that data must not be held for longer than what is necessary for the processing of that data. So the likes of your payroll information, financial details, their 6 years and your 3 years there. How is the data saved? Is it secure? So at a very basic level, do you have a clean desk policy? Would client files be left sitting on the desk overnight that cleaners have access to? Would this be easily accessed by someone who is working late but might not necessarily have authority to certain information that could be in those files? Is your data shared and with whom? So who can access the data that you store? Do you outsource any services? Maybe even the likes of server hosting or like recycling companies, things like that. So you really want to gather as much information as possible under those kind of headings. And it's likely that you'll have to talk to people, in all the different parts that you have in your company to fully understand how the data is used and stored in your practice. So this would include your IT personnel. We've talked about accountability already and the requirement on organisations to be in a position to demonstrate compliance with the new GDPR requirements. So documenting all of what we've just looked at there now will enable the employers to be able to identify gaps in the compliance. It'll hopefully be able to, put in place processes to rectify those gaps, and then ultimately, you can produce evidence of your compliance efforts on the new GDPR regulations.
Yes, this is a really important first step, I suppose. And what we would suggest, it doesn't have to be anything overly complicated. We did ours in-house and we did it in Excel. We list these headings that you see here. We listed them across the top of the spreadsheet, and then we went and created, added each piece of data that we retain along the bottom, and then we just kind of filled in. And as we went along, you can, the gaps in compliance and places where you can improve, they do show it's important. And when we did ours, we broke it down into our client data, our marketing data, and our employee data. So we had a page on each one. And then for us, that just meant we could deal with each area in turn. We could take, what's the project in this side? Okay, the marketing section, we'll get the marketing team involved here if needs be, HR team when we're dealing with the employee data. So just break it down, take it step by step. As Jenny said, you need to talk to different people in the organisation, but it's going to be the basis of how you move forward with GDPR compliance. The next piece is contracts and policies. So I'm going to start off with the contract side of it. Under the GDPR, whenever a controller uses a processor, so there needs to be a written contract in place. So we're talking about here, you are the processor as the payroll bureau and your client would be the controller. So the onus is on the controller, your client, to only use processors or payroll bureaus who provide sufficient guarantees that they will meet the requirements of GDPR. So the onus is very much, as you said, on the controller to instigate putting that contract in place. Now that said, as a payroll bureau who wants to be seen as being proactive in becoming GDPR compliant or working towards compliance as much as possible, I think it would be prudent for you to instigate reviewing your contracts with your clients and ensuring that they are GDPR compliant. And you'll be familiar with your clients and who are on top of this, who know it. And I'm sure some of you have clients who maybe haven't even heard of GDPR. So, your role will then definitely be to try and instigate those contracts and get them in place. Under the GDPR, as we mentioned already, the mandatory content that must be included in the contract has been expanded. And now we've created a checklist of what exactly you need to include in your contracts with your data controllers or with your clients, and we'll send this checklist out in the email after today's webinar. It is also contained on our support pages on our website in the GDPR section. So you can have a look at it there. Now, you might not have to reissue all existing contracts with your clients, certainly not, but at the very least we would be suggesting that you issue an amendment to your contracts that includes the necessary information and you get agreement on that. I have here subcontracting, and so it's also important here to consider any sub-processing. Sorry, I have subcontracting. I should have sub-processing there. My apologies. It's very important to consider any sub-processing that you may use. And we touched on this earlier. As a data processor, you must not engage in any sub-processing without the written authorization from the client in advance. So I was trying to think of an example of this, and the one that came to mind actually is that if you're using BrightPay and you send a payroll backup into BrightPay for support assistance, and our staff are looking at that file, we're processing it and we are sub-processing. So this is of course, it's perfectly acceptable. And we take backups as a last resort, and sometimes it can be the only option in terms of providing assistance and getting the issue resolved. So it is acceptable, but just you need to be aware of it. So under the GDPR, for you to be able to send us a backup, you need to have written consent from your client. Now certainly you wouldn't have to get this written consent every time you wanted to send a backup or every time you interacted with us. Or any other sub-processor for that matter, but it would be advisable that in your contract, when you're writing that contract we're talking about, that you list the sub-processors in your contract and you get authorization that way. Now, of course, we would have responsibilities as well, and we need to put steps in place, and as I said, we're going to touch on BrightPay as well. And then just finally on this point, in addition to your contracts with your clients, you'll need to review any other contracts you have with any other third parties to ensure that they too are GDPR compliant. So then just to move on to privacy notices, your privacy notices are really, really important under GDPR. So, having done your data inventory, armed with all your collated information from this inventory, you'll need to review your data protection notices and analyse whether they require any updating to ensure compliance with the new rules. If you don't have any data protection or privacy policies in place, you're going to have to start to put these in place. Similar to our contracts, the information that we need to provide in our privacy policy is more detailed again under the GDPR. And once again, we've created a checklist of what you need to have in your privacy policy, and we'll send this link to you again in our email after the webinar. But I just want to touch on a couple of points that we've included in the checklist. And one is transferring data outside the EU. And the transfer of data outside the EU is something that's kind of a new concept, and it's dealt with in the GDPR. They allow it, but they put restrictions in place around it. So if you do, or if you intend to transfer an individual's personal data outside of the EU, you need to ensure that there are approved transfer mechanisms that they're in place. So at the outset, you might not think that you transfer, well, we're a locally based accountancy firm, payroll bureau, we don't transfer data out of the EU. But if you are using a host server, perhaps somebody like Dropbox or Google Drive, then the chances are that you are transferring some data out of the EU. So some form of reference to this should be made in your privacy policy. And B, you also need to check that your provider is providing appropriate security. Now, we've looked into Dropbox here from our own regard, and certainly Dropbox have secure measures in place and appear to be a safe server. But it's about just making that process and making that consideration. You're not going to put a specific contract in place for somebody as large as Dropbox. So it's about you doing the due diligence and checking it out. The other point that's on the checklist when we talk about privacy notices is data retention periods, and Jenny talked about this a little earlier on. The GDPR does not specify any particular retention periods for personal data, but it does state that personal data may only be kept for no longer than is necessary for the purpose for which it was processed. So when considering retention periods, businesses should be guided by statutory retention periods and your own business needs. So it's very important to set out in your policy how long you're going to hold on to data for, and be guided by statutory legislation. For example, employment law sets out some particular time frames as well. So just kind of when we compare contracts and privacy notice, whilst your client contracts will be very specific to your individual clients and the agreement that you have in place with them, your privacy policy will set out your practices and approach in a more general term. Generally, you'll see privacy policies at the end of companies' websites, etc. But certainly it's equally important to have it in place. And I put in employee privacy policies here. I know we're talking about payroll, but just to touch on the employee side of it, you will also need to, because you're holding personal data from your employees, and we talked about the enhanced rights earlier for employees, they equally apply. So you will need to have a privacy policy in place for your employees. Or if you don't have employees, you should be guiding your clients that they should have privacy policies in place for their employees. If any of you are Bright Contracts customers, you'll be familiar with the software. We're developing our privacy policies, our employee privacy policies, and they'll be going live in the Bright Contracts software very shortly in the next few weeks, I would say. And then the final point just on contracts and policies is that when writing any of these, either a contract or a privacy policy, technical language or legalese should be avoided. You have to keep your documentation in an easily understandable and easily to follow format.
Perfect. So moving on from then, we're going to look at capturing consent. So as Laura has already said, if you're relying on consent as a legitimate reason for processing data, you need to step back and take a look at how you're actually getting that consent, and is it compatible with the new GDPR regulations. So for example, if you have mailing lists that you've used pre-GDPR, you may not be able to continue using them if you haven't got specific approval from the individuals. I actually received an email shortly after the last webinar we did, and I kept it just to kind of show you. So I'd obviously signed up or registered for a newsletter a long time ago. I can't remember it. But basically this email comes in and I just delete it every week. But I read at the bottom of this email last week, you are receiving this email because you have either expressed interest or purchased a product through me or this particular company. So for the likes of that, it's not necessarily in relation to a mailing list, but they have kind of done that. This is, you're consenting to everything. So by signing up to the newsletter, you're basically allowing us to contact. Yeah,
but they've sent you this, possibly by virtue of the fact that you purchased something from them, now you're on their mailing list, which under GDPR will be inappropriate.
Absolutely.
And that will go for your clients if you send out a newsletter at the end of every month to all your clients, which has a sales focus on it or some sort of a marketing spin. You're going to have to ask your clients to opt into that. If it is just an informative newsletter telling them about recent tax changes or whatever legislative changes, that should be okay. We will obviously send all our customers BrightPay updates necessary for the running of your software.
Yeah.
But we won't necessarily send you marketing updates.
No. So, and another point to be aware of here is that at the point where you're asking someone for consent to process their data, you must make it clear to them that they can opt out at any time. And you must make that opt-out process seamless and easy for them to use. So then we're looking at governance. So under the governance heading, you want to develop your compliance methods. So to ensure that having put the initial steps in place, you can actually be compliant then going forward. So this might include the likes of reviewing how you deal with the data subject access requests. Who will they go to? Consider, can you gather all the information? Is it stored in an accessible format? Is the data saved across a number of different systems? Appoint the data protection officer if necessary. And again, as Laura kind of said, we don't want to make that sweeping statement, but it's unlikely that most payroll bureaus would need a DPO. But having said that, you should at least be able to document some sort of thought process around the governance and who might deal with those situations as they arise. And then updating your staff on data protection. So you want to spread the awareness of GDPR across the organisation, and it really needs to come from the top down to make it, appropriately conscious. We still get phone calls in from people, and you mentioned GDPR, and they've no idea what it is, and then you have people who are completely panicked by it altogether. So there's completely different ends of the spectrum, but knowledge is the key, and once you have that, then we'll be doing well. So then moving on, security. So this is another really important point. Obviously, we live in a world with ever-increasing threats of cyber attacks and ransomware attacks. There was quite a few of them, high-profile ones last year in the news. There's also the risk then of malicious insider attacks. So, thinking back to the Morrison's case there with the disgruntled employee, and then not to mention accidental breaches down to human error that Laura spoke of earlier on.
Yeah, and the human point is an interesting one. It's probably one of the main reasons why companies can never actually fully say we are GDPR compliant, because you just can't plan for everything, and that human error you can't plan for. And human error is one of the areas that causes most breaches, or many breaches, should I say, particularly if you have mobile working. Mobile and remote working present a whole range of additional set of challenges for IT security, and there's again really interesting cases. It's not a payroll related case, but I just thought it was interesting. I'm going to say it anyway. But a couple of years ago, the MI6 worker who was obviously working from home the next day, and they went out with their laptop. They obviously had one too many drinks. They left their laptop in the taxi on the way home. And you think this is an MI6 worker, but it just goes to show that's the risk. And the human error, you can never say you're 100% compliant, but as a company or as a bureau, you want to be able to show that you've taken as many steps as possible to be compliant.
Exactly. So in terms of what can you do to protect against the likes of human error, first and foremost, you need to review your data breach reporting method. So do you currently have a process in place? Who would make the final decision on if a breach should be reported? And who should the breaches be reported to internally? And we spoke earlier about taking preventative steps, both technical and organizational. So on the technical side, do you have encryptions or pseudonymizations in place? And are they tested on a regular basis? You need to set the likes of strict access rights, and this would mean that should an employee's laptop or other work device fall into the wrong hands, they would only be able to view a portion or gobbledygook if they were able to actually access the information. On the organizational side then, give each user the minimum access they require to the systems for them to be able to complete their jobs. Allowing staff wider access to systems puts you at a greater risk of a data security breach. So only give your employees access to what they need to actually work on. Or perhaps you need to consider a remote working policy, so laptops can't be brought to the pub. That would be a good one.
MI6 could consider that one.
Absolutely, yeah. There's a few other ones in there too. So that's your security. And then just very briefly, your data by design and your protection impact assessment. So really what you're looking at there is developing a privacy impact assessment and a privacy by design implementation and review that process. So again, you're just putting the thought process into place. You know, the privacy by design, the privacy by default, and then your PIAs.
It's embedding it in your organisation.
Exactly, yeah.
And if you do change how you process data, or you bring in a new way of processing data, then consider whether you need to complete.
Absolutely. So a new system, if you bring in a new system, you know, whether it be an account system or, you know, a new remote server, something like that, that's when you would be using the likes of your privacy impact assessments.
Perfect. Okay, just really quickly then, because I'm conscious of time as well, just the role that we think you could play in advising your clients. 99% of the UK's 5.5 million businesses employ fewer than 250 people, and that proportion is growing. So when it comes to data protection, small businesses tend to be less well prepared, and we would see that with our clients, and I know a lot of you here today will agree with me. They have less to invest in getting it right, and they don't have the compliance teams or the data protection officers in place. But small organisations often process a lot of personal data, and the reputation and the liability risks are just as real. Contrary to some opinions that we hear out there, the risk is just as real. The GDPR makes some derogations for companies with less than 250 employees in terms of what reports, record keeping you need to make, but other than that, the legislation will apply to them. So as a payroll bureau, as an accountant who provide advice to your clients, we think you're in a good position to explain to your clients and organisations how the issues that we've talked about can affect them. And, you know, we think it would just, you know, give you a competitive advantage, I suppose. And even if all you do is advise them that we're having another GDPR webinar for employers in March, they might want to come along too as well. You might want to do that as well. Okay, I'm not going to go through this slide. This is just an ICO slide. They've done we did 7 steps. They have a 12-step guide on how to prepare. As I said, the ICO website is fantastic if you're looking for a range of information. The commissioner has written several myth-busting blogs, which are really easy to use and clarify, or easy to read, should I say, and clarify certain areas. So do have a look at that as well. Okay. Before we finish, we just want to discuss how BrightPay is preparing for GDPR. Data protection has always been a concern for us, and we've always aimed to act with complete integrity in this regard. But like all companies in preparing for GDPR, we did have to sit back, take stock, do a data mapping process on the data that we held and how we were obtaining that data, etc. I have to say that the process of doing that was a quite interesting learning curve. Looking at some of our processes, we realised that perhaps they weren't the most efficient, and we took the opportunity to improve how we did things. Again, my own take on GDPR is that holding data has become something of a curse. Getting rid of it as soon as you can, and I would advise getting rid of it, what you don't need, as soon as you can. And while you do hold it, make sure you keep it as safe as possible and only hold on to it for as long as needed. For example, we don't hold customers' credit card details, and thank goodness for that, to be honest. We do hold names and addresses of our customers because we're obliged to keep them for 6 years. Otherwise, we would probably delete them as soon as we could as well. In terms of our software, I think the first thing to say is that BrightPay does not have access to your data files, except where they have been submitted to us for support reasons. So we have no control over the authority, the quality, or the safety of the data input. You and your bureau are responsible for the accuracy and completeness of your records. That said, we do have security measures in place to protect your data, but again, it does remain your responsibility to keep your sign-in details secret and sign off from any BrightPay product when you are not using it to ensure there is no unauthorized access to your computer. In terms of what we have done, I'd like to go through some of the key changes that we've made and how they'll affect our customers. One of the key aspects that came from our inventory list was that from time to time we do, in order to fully resolve a query, the only solution is for us to request a backup in of our customer's file. And we did have security protocols in place for this, but we did feel that we could make them even more secure. So we've created an an in-program support feature that allows users to automatically send a backup of their payroll or your client's payroll to us through the secure channel. The benefits being that you don't have to upload a backup to your email where you may forget it and delete it, and that means you've got client data somewhere else. But mainly on our side, the backup never gets saved onto our employees' PCs. It's all saved centrally on a secure server, and then it's automatically deleted after 1 week. So this particular feature was included. It's included in a recent upgrade, was it, Jenny?
It was added to the 17-18 software, so it has been there for quite a while, and it is actually very easy to use. One thing we kind of found over the phones, it was quite difficult to actually talk people through attaching things to email, so it's eliminated that, and it is very widely used now, yeah.
And we've also worked on increasing our own encryption and the data files, just in case some hacker does manage to access your file. There is increased encryption there as well. We are currently finalising our own privacy policies, and these will be going live on our website shortly. So in our privacy policies, we'll be addressing some of those points that we talked about earlier, that as a processor, we need to be setting out to our customers. So they'll all be in our policies, and we've tried to make them as clear as possible, and I think we're happy with where we are with them. Similar to what we said earlier about deleting files, we've also completed an internal IT audit on every company PC, deleting any necessary data. So this has really helped us know what data we hold and keep on top of the data that we have. And going forward, our plan is to run these audits regularly. And again, it's just a great way for us to keep track of our data.
It was actually, we had a meeting there this morning, and I know maybe we might touch on a little further on, but the simple little thing of even keeping a notebook on your desk, we've introduced a policy now whereby at the end of every week, all documents that is no longer, relatable to a customer file or anything like that needs to be shredded. So a shredder is going to be put, beside the printers, simple little things like that, that we've you might necessarily think of, but actually.
Yeah, obviously the first things we think about is the encryption and the data and the software, but then you work back from there and you think, the people issue, we need to make as many internal changes as well as we can. Our CRM, I think that's the next one. We've had a look at how information is sent to and retrieved from our secure servers, be it for the purposes of maintaining our websites or our CRM. And we've now changed all our servers over to a more secure Microsoft Azure servers, which are EU-based actually. And we've introduced IP whitelisting, meaning that knowing the login credentials is not enough. The request has to come from a trusted location. So if it were that one of our employees' laptops was stolen, access couldn't be obtained because it wouldn't be, or unlikely to be, at a whitelisted location. We've introduced extra consent fields in different areas of the software in our websites. So going forward, with the exception of essential software updates, as we said, customers will not be contacted unless they have specifically opted into our mailing lists. Although we're a little biased and we say, obviously signing up to our newsletters, you get information about excellent webinars such as this, so we would highly recommend that you do.
You wouldn't want to listen to us.
Internally, we're holding lots of staff training, and as Jenny just said, we have weekly meetings, and GDPR has just become a topic on the agenda now. So all our staff are fully aware of the legislation and how it impacts on their role as well. And finally, we touched on it briefly earlier, Bright Contracts. For you Bright Contracts customers, we will be updating our data protection and employee privacy policies within the software over the coming months. And we'll send you notifications of that. And instead of, even if it's not something that you necessarily need yourself in advising your clients, that might be one that you might want to advise your clients on. Okay, so we're 5 minutes over, which I think was good going. There's loads of questions that were coming in, and quite long questions as well. We're going to try and get to them. Just bear with me now for a moment till we bring up the questions and we get ready for our Q&A sessions. Thank you all very much for your attention. I hope you found it useful. So just bear with us a moment.
So one of the first questions here is, how can you operate GDPR when you take into account HMRC requirements to keep records for 6 years? So we did touch on that. Your legal requirement will take precedent in relation to that. So in relation to be able to fulfill your kind of legal requirement as a payroll provider, you will be required to obviously keep certain information for 6 years, other information for 3 years. So that does take precedent over the GDPR regulations.
Yeah. The next one is in relation to biometric data. How can we justify using palm print scanners other than for timesheet management? Can we just obtain consent from employees to avoid any issues with GDPR? The issue with consent from employees, we didn't really talk about it here, but consent is not in most cases going to be a suitable lawful reason for processing employee data. The reason being that there's an imbalance of power between the employer and the employee. So the employer holds more of the power, and consent has to be given freely and unambiguously. So in that regard, you cannot rely on consent when you're talking about processing employee data in this regard. But this is a question we've got a lot on, and we actually rang the the ICO on this just to get their kind of and their kind of say on it as well, and they were kind of in agreement at the moment as the GDPR stands, or when the GDPR comes in as it stands at the moment, unless you have a legal obligation, which I don't think timesheet management is, you can't rely on palm print solely. So as we said earlier, you might be looking to promote it maybe as best you can within your employees, but those people who want to opt out, you'd have to have an alternative method.
I think the guy in the ICO actually said that, unless you were kind of storing, hugely sensitive information, kind of on your premises, so the likes of the MI6 would probably require hand printing or kind of detail like that, then it really would be hard to justify it. Mm-hmm. This question came up last week, and I actually don't know what our answer to. One of the girls in the office actually asked me this. What happens to data for the lost client? So does this need to be deleted? What if there's a subsequent request for information for this client who's now left you or his current accountants?
My understanding of this now, I'm open to being correct. My understanding is the client has the responsibility to hold their records for 3 years or for 6 years under HMRC. So it's the client's responsibility. It's not your responsibility as the payroll bureau. However, the client has outsourced that to you. If the client then decides to move from you to a different payroll bureau X, you no longer have that responsibility. It is now the client's and the new payroll bureau. So I don't think there is a responsibility for you to hold on to previous clients' data once they've gone there. They've left you, so, let them go, I suppose. Has BrightPay got a template for consent? Well, we asked for consent when signing up for a newsletter, so you could certainly take that if you wanted to use it as well. Oh, okay. Sorry. Jenny has messed up our questions on us and totally lost where we were. We're going to try to get to as many questions as we can. Hopefully we'll get to them all, but as I said, they're coming in such an amount, we may miss one or two. If we miss your question, we'll try to get back to it later on today as well.
When processing a new employee, is information from the employer sufficient, or would you need a signed document from the employee to confirm consent to add to the payroll? So Laura touched on this earlier on. You are the data processor, but your employer is the data controller, and it'll be through the controller that the employee will make requests. So the consent doesn't need to go to you from the employee. The contract is with the employer and the employee, and you're a third party to that. So what information you garner from the employer is
it's the employer's responsibility in their employee policies and procedures in-house to notify their employees of who they share information with. So that's the responsibility of your client, and then it's just important for you to have your documentation in place with your client. The next question there is, what is the position when a client moves to another agent and the current agent is asked to provide handover information, including the employee's personal data? So kind of a follow-on to that other one that we just asked previously. What I would do here is, if I was asked to provide information to the new payroll provider, if I'm understanding that right, or maybe get approval in writing from your client that it's okay for you to pass this data on to the new person. And once you get that, I think you would be fine.
Exactly. There's a question there. So do you have any forms we can complete to ensure we have complied with the legislation? Again, you know, there's an aspect of you know, kind of human error in this. You know, it needs to be seen that you've done your best to become compliant with the new regulations. It's unlikely really for anybody is going to be 100% compliant, but I think the focus is that you're ensuring you're taking data protection into consideration at every kind of junction and every kind of parapet in the company processes and the policies that you have in place.
Well, just kind of come in there, what I kind of say to people is you create your GDPR folder. Now, whether that's a Dropbox folder or an old school lever arch folder, and maybe you pick a checklist that you like. You might pick the ICO 12-point checklist, or you might decide to take our 7-point guide, or different checklists that are available. They all have very similar content. And in your folder, be able to document how you have moved through each of those steps. And should, God forbid, anything untoward happen, then you have a breach or an investigation. And when the ICO were to come to you and say, well, what had you done to prevent such a thing happening? You pull out your folder and you say, well, we had done a data inventory, we updated our policies, we improved our encryption, you know, and we had internal policies for employees to abide by. So you have all that there. So you just kind of as much, it's to create that accountability, but in terms of rubber stamping it or getting approval, it's very difficult. Now there are those ICO certifications that you get. They're costly. I don't know the exact figures, but they're quite costly. ISO figures. I don't know if many small businesses would be going for that.
Going down that route. As an example, would emailing pay slips for a particular client being sent to another client in error require reporting requirement to either the ICO or the employer or the employee? That obviously would be deemed as a breach. You would have to, you know, kind of deem whether or not it has been classed as a risk to, you know, the integrity of the individuals in question, or is it a high risk? So if it's just a risk, then you would need to report it to the GPC.
To the ICO.
The ICO, sorry.
Yeah. I suppose it depends as well on what information you include on your pay slips. If it's just name, you know, you could argue no, possibly not. If you have more specific employee information detailed on the pay slip, again, you'd need to consider that, and maybe you would. What about small organisations that are too small to employ anyone? Oh, that person has left, but yeah, small organisations probably, I presume they say too small to employ anyone for this role. That might be the DPO, and they probably wouldn't need a DPO, but they would just need to have somebody in-house who kind of is semi-familiar with it. We're just reading some of the longer questions, bear with us.
For a free initial consultation with prospective clients, are we still going to be able to take copies of photographic identification and proof of address for anti-money laundering purposes at that meeting?
I'm not familiar with anti-money laundering legislation. We've had a question on this before, but you will have anti-money laundering obligations that you need to tick and get. So if it is an obligation, then your legal obligations are going to override any kind of other reason. So yes, you could possibly still take it. What I would be setting out is very clearly how long you then hold on to it thereafter. And maybe your anti-money laundering will give you guidance as to how long you can hold identification, photographic identification and proof of address for non-customers or non-clients if they don't become a customer. I take guidance from the legislation on anti-money laundering there. So you probably still can if it's a legislation thing, but just be very clear on as to how long you are holding on to it after.
Okay, this is actually a question that we discussed ourselves this morning. So what responsibility do we have in respect of gaining assurances from software providers that are if they are GDPR compliant, and do we need to include this somehow in our contracts or GDPR compliance documents? If you are the processor of the data and you're using a third-party software, then you are liable to ensure that that party is
GDPR compliant, or has as many measures in place as possible.
Exactly. Yeah.
So, for your small, you might have a relationship with a local pension broker, so it's a very close relationship with somebody like that. So you could ring up with them and put in a written contract, and that would all be fine. For the bigger companies like the Iris, and Sage, well, why are you using Iris and Sage? You should be using BrightPay.
Do not need their consent to say that.
You might not, for the bigger companies like as well with Dropbox. Dropbox are not going to issue a contract with every single client. It's just not going to be feasible. So, but you do need to, as you say here, just document it, and we talk about it in your compliance folder or your GDPR folder. List any kind of providers when you're doing your inventory. Yeah, we listed Dropbox, we listed Google Mail, and then just tick off them that you've gone out to them, and you can see in their audit reports, if their audit reports are online or in there. Usually, like Dropbox has, any company of this size of nature will have a GDPR section on their website, and they'll be telling you how they're compliant, what they're doing. So for the larger companies, if you've done some due diligence on how they're complying, I think that would be sufficient. And there's lots of questions about the screenshots and slides. Again, we're emailing them over afterwards.
Do you need to have written authorization to send emails containing VAT returns? I am assuming that you would be using a software program to create the VAT returns, and that program then would have to have some form of encryption on your emails. It could be like a password protection on the attachment, so that's going to be down to whoever you actually use in relation to that. Yeah.
Sorry, where are we now? Yeah. Sorry, someone says, what about Office OneDrive? Same concept will apply as Dropbox or Google Mail. We don't use it here, so again, but you just have to go onto their website or send an email to their support. There's usually general email addresses. Microsoft Office is a US company, so it could again be a US-based server that they have. I don't know, but you just need to check that out. If it is a US server, that will be fine once they have those securities. So just look to see have they got the security in place.
I think that's like the out processor.
If payroll is outsourced to another firm who remotely access the data by logging into our server, is this a transfer of data, not the same as sending it back up? Would we need to list and specify? Yes, would you need to, if you've somebody, you're outsourcing part of your payroll to a different firm who are logging in externally and accessing that data, do you need to list that in your agreement? I would. It's all about transparency. I would be putting that in. Equally, when people purchase from our website, we don't hold on to credit card details. We never access the credit card details. They go to payment providers, solutions, Relex, things like that. We need to tell our people that they're accessing it. It's not that we're sending it to them, but they're accessing it. So I would, yes, I would include that in my contract. Keeping data for as long as necessary for the purposes of which it was sent. What if we delete the data and then the client sues us for something we have no evidence to back our claim of actions? I don't know if that's really relevant to exactly, what I'd be setting out in my data and my privacy policy, how long you were holding data for, and I would certainly, from an employment point of view, I would always hold data for at least the period of time before an employee could bring a claim, so I'd be looking at, to well cover that if it's 2 years or something after an employee is left. But it's a difficult one to answer, I suppose. So just reading on to the next question now. We have a contract between us, the payroll bureau, and our client. we are presuming us is the Payroll Bureau.
Mm-hmm. We then provide contracts for our clients and their employees. I'm assuming that's employment
Do
contracts.
we now need a contract between us and the employee as we have personal bank details on that? No, this goes back to the question that we asked. That's saying, do you need a contract? We have a contract between us, the Payroll Bureau, and our client. We then provide contracts for our clients and their employees. Do we now need a contract between us and the employee? A bit of a tongue twister, as we have personal bank account details on them. No, you don't need a contract with the client's employee. It's just important that the client has a contract with their employee, but the privacy policy is probably going to be in addition to your contract. It'll probably be in the handbook. So you'd have to review the contracts. Do they include a privacy policy and an updated data protection policy? And that's what your clients should be really putting in place with their employees, but you don't have to have anything in place with the employees once you have a robust contract in place with your client.
Somebody's asking, can we continue to email payroll info to clients and pay slips to employees? Yeah, I mean, you're under obligation there in relation to your contract with the employer. So if for purposes of payroll, you're emailing the pay slips to the employees, absolutely, there's no issue with that. You just need to be seen to have, kind of looked at the security aspect of it. So on the likes of your BrightPay, you have the password facility on it, and plus that information is encrypted from within the software as well.
Another question there, can we begin to delete old data for payroll over 3 years now? That's my understanding, Jenny. Did the HMRC require records for 3 years?
Yeah, payroll records for 3 years. The likes of your financial records would be 6. Yeah.
Is a small business actually expected to encrypt their own single computer? This can be really dangerous as we could lose data. Well, it's probably not for us to say whether you are or you aren't, but you are expected to take all reasonable steps to what would be secure for you. What's actually helpful here is that, talking about the ICO and the useful information that they have, they've developed a IT security help sheet or guidance for the small employer as to what you should do. So actually what we might do is send a link to that as well. I'm not a data encryption specialist, and certainly it's an interesting area. I'm definitely going to gain more insight into it, but we might put that link at the end. So I'm not saying you do have to, but even to have the consideration. You might decide that your single computer as a sole trader or whatever is just based in one location all the time. Only you have access to it. Only you have the password logins, and there's relatively low risk, so you mightn't feel you need to do it.
There's different forms of encryption as well. I mean, obviously encryption just kind of means that that the files can't be read. It'd be just pure copy. But there's pseudonymization, which kind of partly it kind of not replaces information, but it kind of turns things backwards. So some information may be available. So there are different aspects, but as Laura said, that ICO help sheet is very useful on that.
Just a quick one. I don't know if you've just answered something similar. Are we still okay to email out employee pay slips? Yes, that's perfectly fine. Obviously how you email them out should be encrypted and secure, but if you're using particularly BrightPay, we recommend you have a password on all email pay slips, and our servers are encrypted, so that's generally safe. Emailing pay slips, similar question, on behalf of employees or a portal solution. I would be inclined to veer towards the portal solution if it's there, because it's a secure server and it's not going in transit. Maybe it reduces the risk, and because of that recommendation in the GDPR that if there's ability to have a portal solution, go with the portal solution or do provide it. But the email is perfectly acceptable as well.
Somebody's asking, can paper pay slips be sent via Royal Mail? This came up the last webinar we had as well. And yes, again, once you've been seen to kind of ensure security measures, so that could be like a security pay slip, well, then it is still fine. But
still fine, again, just all the security you can take, whether it's registered post or...
Exactly, that it needs to be signed by the individual employee. But yeah, it'll still be okay.
Does any part of GDPR apply to companies operating their own payroll? Yes, absolutely. Obviously today's webinar was focused on payroll bureaus, so that's our slant. But as we said earlier, all the enhanced rights for individuals apply to your employees, and they will apply just as much to your in-house payroll as it will to any payroll bureau.
Mm-hmm. Oh, that's an interesting one. As we're being pointed towards cloud-based products more and more now, what happens if they have a breach of data? Are we then responsible for that? It'll depend obviously on the breach itself.
Yeah, and where the breach occurred. If it was a breach of data because somebody accessed your login details and accessed the data that way, well then, the liability or the responsibility is going to lie with the user. If there was a back-end cyber attack on the secure server that the particular cloud product was using, well then that's the responsibility of the cloud provider. Just to mention, obviously we have to Connect, that's powered by Microsoft Azure. We have some of the top tech IT guys, and we're very confident it's in its security, and as I said earlier, that's all EU based as well. Just going through a few more, lots of ones on the pay slips.
On the pay slips, emailing it, email is fine.
We give all new clients an engagement letter contract, excellent, of services, accounts and payroll. Is it fully sufficient for consent? Is that fully sufficient? Okay, I'll just read the question again. We give all new clients an engagement letter or contract of service for your accounts and payrolls. Is that fully sufficient for consent as a lawful legal basis? I think you may be slightly confused here, because you do not need consent from a person in order to process the payroll, because you're entering into that contract. So they've requested it, and then you need a lot of that certain information for legally processing the payroll. So you need it for the fulfillment of the contract and to legally process. So going back to Jenny's slide where she had lawful reasons for processing data, one of them was consent, absolutely, but it's or. So
once you met, whether it was if it was for lawful processing, if it was for by means of completing a contract, or
yeah. But I suppose to summarise your question, yes, your contract here or your engagement letter with your clients will be sufficient, because that'll be the contract that you're signing into. But what I would advise is that you maybe review that contract to ensure it has those extra clauses that the GDPR now requires, and particularly in relation to maybe any sub-processors.
Sorry, we're just reading. There's a couple of long ones in here, so we just want to try and cover as many of them as we can.
Sorry, somebody there is just wanting to trial Connect, as though most of the criteria are already met, with simply making sure my contracts and privacy policy state. So Matthew there, you're saying you're interested in Connect. We might come back to you separately and to talk about how it might meet your needs.
Hi guys, great presentation. Thank you, Chloe. How, in your opinion, will GDPR affect the use of data transfer to and from clients? For example, emailing a payroll report to a client.
Again, it's the same as emailing your pay slips. It shouldn't affect it once you can show you've taken appropriate security measures, again, whether that is passwords or encrypted, or equally again using a portal which, similar to Connect, that the information, once you finish your payroll, it's available, that information, your payroll reports are on Connect, so there's no need to email reports over, it's just there. There's still more questions coming in, so a few people are leaving and absolutely work away, but we'll just keep going for another little while with the questions, I think.
What does the ICO stand for?
Information Commissioner's Office. As ico.org.gov, I think is the website, fantastic website.
Do we as accountants agents have to be registered with the ICO for GDPR? So Laura actually touched on that, so I do believe you do still need to register for them. For the ICO?
If you go onto the ICO website, right along the right-hand side, one of the first things that says register here. And when you're registering, you can do a little almost, do I have to register? And there's a little small short questionnaire, and it'll ask you a couple of questions, and if you answer yes or no, depending on what you answer, the ICO website will tell you that if you need to register. I would imagine because most payroll bureaus or anybody processing payroll has employee data, they will have to register with the ICO rather than with GDPR, if you understand.
Mentioned Dropbox. Do you know if Dropbox is GDPR compliant? I heard from various sources that it is not, as the information is not encrypted. Following on from there, is there a requirement for information to be encrypted, i.e. can payslips be sent over email? The payslips can be emailed, yeah. We've
And emails from BrightPay are already encrypted.
Encrypted, yeah.
If this is one on physical records and files and folders are held in a filing cabinet. So if your physical records are held in a filing cabinet, which are locked at the end of the business day, every day, is that sufficient for data security purposes? Yeah, that person has left now, but just to say physical records are covered under GDPR as well, so it's important to remember that. It would be secure that you lock them at the end of the day, and only people, relevant people or necessary people to see that information would have the key to whatever filing cabinet that is in.
Yeah, at our last webinar, we were asked the question, somebody took kind of customer names and phone numbers and contact details in a foolscap folder, and the question was, would it be sufficient to close the folder at the end of the day? Would that be deemed as being GDPR compliant? So that wouldn't. And again, you're just kind of looking at your processes that, once your cabinets are locked and things are put away and you've got like a clean desk policy, or you have a shredder beside your printer and you're shredding documents as you no longer need them, you're seen to be security conscious.
Just one there, Jenny, you're probably better than me. Regarding subcontracting, I complete CIS returns for companies. Does each subcontractor need to give me permission to submit and verify their data? I'm presuming that's a legal obligation.
Yeah.
So by virtue of the fact that you're
contracting or you're processing the information for them.
Yeah, it's a legal requirement, so it's almost like doing the payroll. You're doing that as a legal requirement. So you have your contract in place with them for agreement of your services or your engagement letter, etc.
Yeah.
But you don't need specific extra consent for them to subcontract. As you say, it's not really subcontracting. The sub processing is more where it's a non-legal person. Or for non-legal reasons, probably.
Yeah. I'm a sole practitioner. I don't employ anyone. I outsource various aspects. Is this a problem?
There's not a huge amount of information there. Right?
No, we'd have to kind of know what it is, what area you're looking at. Okay, they're still coming in quite long emails, so just bear with this second one and get through a couple more.
Would we need written consent from the client or employee? For example, if the DWP send us forms to fill out about employees. I think, again, that's coming from the DWP, that's a pension. That would be a legal obligation to fill it in. So as part of providing your payroll services, you'd have to complete that. I don't think you'd need to fill out that consent. It's similar to the last question we did.
Yeah. Again, emailing the pay slips.
It's fine, but no harm in clarifying when you're setting up your agreement with your clients how you send pay slips and getting their agreement at that stage.
Lots of questions at the pay slips.
Yeah, totally fine to email pay slips once it's secure.
Yeah, same with posting.
Same with posting, yeah. With new starters employees, will it be okay to email the employer any questions you may have regarding this new employee? Absolutely, yeah, you would expect you would, because that is for you to provide your service, to provide the full payroll bureau service to your clients. That'll be fine.
Yeah.
If we have to set up passwords for email and payslips, does this have to be company password, or does each payslip need to have an individual password, and who decides the password? Yes, if you are applying passwords to your email and payslips, each email payslip should have its own password. It should not be a company-wide password because if one employee accessed a different employee's email account, well, sure, they would have access to all their pay slips. Ideally, it should be set by the employee.
Generally, the employee would set it, but if you do have a preference for the password protection on the pay slips, BrightPay has a facility of actually creating an encrypted password for each individual that's completely different and separate for each person as well. So that option is under the employee section, under the passwords.
Can I share the recording with my employers? I presume you mean the recording of today's webinar. Yes, please share it with whoever you need to. That's not a problem at all.
Yeah. Or else they can sign up for the
our next webinar on the 13th of March. Absolutely. Yeah, and that would be a great way to show that you were informing people about the changes.
How can we best serve our clients who do not know anything about the GDPR? So, Michelle, again, that's coming down to, kind of advising them. Laura had it in her 7-step process there as the last option. It's not something that you have to do, but certainly from the position that you hold, it would be, a nice thing to be able to...
I think it's a nice value add, really, for you to say it. And maybe it's, if you are... in your next communication with that client, whether it's sending you over payroll reports for the end of the month or the end of the week, or whatever your payroll period is, maybe perhaps at the end of that email, it's just, have you heard about GDPR? We recommend you read something up on it, or if you send them a link to something, or even send them a link to the next webinar would be.
Absolutely. We have a number of blogs on the website, brightpay.co.uk that go through the, kind of steps on how to ensure compliance on it as well. So there'd be no harm in sending them a link to those.
Still some on the pay slips. Was I correct in hearing that if we send pay slips by post, sorry, let's just get the end of that one. If we send pay slips by post to employers and P45s directly to employees, we have to send them. No, you don't have to send them by recorded delivery. Certainly not. That was just a suggestion if you want to ensure security. You just need to ensure that you're confident with the security. There's an interesting case, actually. It relates to HMRC, and it goes back a few years. It was a massive case, and maybe some of you are well aware of it, where 2 HMRC employees were sending data to the National Statistics Office. I'm not familiar with the exact names of it at the moment. So they were sending
There was CDs or
floppy disks back at the time, and they sent these 2 floppy disks to the statistics office by regular post, and on these disks was huge amount of information of all workers in the UK, of every child under the age of 16. Those 2 floppy disks never arrived. They have never been found to this day. So this is 10 years on. So we don't know who has access to those floppy disks or where they've been seen. So you just have to weigh up the risks involved and how can you be sure that you can put in as much compliance as possible. I think we're coming to the end of the questions, are we?
Yeah.
How does GDPR affect the retention of hard copy files where clients failed to collect them? I'm not entirely sure about this question. I don't know why would a client fail to collect them?
I don't know. Is that maybe where a client is leaving and going to a different practitioner?
Well, if they're no longer needed, I would say shred them, but make all
kind of ensure that you have tried to contact the employer, whether that by registered post or email, and that you have proof that you tried to contact them before you do anything with it. If an employee emails us asking for copies of their P60s or pay slips, will we have to ask them to contact their employer first? This came up the last time, and I do believe...
You don't have to, but I would recommend you do, because your relationship is with the controller,
which is the employer. You want to keep that, at a different standpoint, really, and the relationship, as Laura said, is with the actual employer as opposed to the employee. So it probably would be more relevant to pass them back to the employer.
If an accounts practice or payroll bureau sends payroll to, for example, India to be processed, does the accountant or does the client have to be told where the data is going, or merely that a company outside the EU is being used? it's all about transparency and being as transparent and open as possible. I would say you should tell them exactly where the information is going, and I would very much expect that they would, if they see it's going outside the EU, the next question they would say is, well, where? Because certain countries outside the EU, like Canada, for example, are really forward-thinking, and they've been one of the kind of leaders in data protection. And there's more kind of, if it's being stored in Canada, there's definitely more security taught to be in place, where I don't know what it's like in India. So A, if you're sending the information out to India, yes, you need to tell your clients where it's going. And B, you can send information outside the EU under GDPR, but you have to be sure there's a specific list of regulations that must be met, of security regulations or sort of security measures that have to be met. So you have to be sure you're able to tick one of those boxes. Is operating a clean desk policy mandatory under GDPR? An accountant's office will always have accounts files and jobs at various stages in progress. No, it's not mandatory. We've just maybe suggested as a possible thing that you might like to do, because if somebody is away from their desk and there is client information on that file, it could be on that desk, it could be argued that that is an unsecure data on your desk, and you know who will be in your office overnight. Will it somebody who should not have access to that data? Could they possibly access that data? And that's what we're saying. It's up to you to make the call and you to decide. We would probably suggest, you know, maybe put in a clean desk policy in place, because it's that the people element and the human error is the significant risk as well.
It'd probably be prudent from the likes of an accountancy firm who's dealing with a lot of you know, personal data belonging to clients, employees of clients, customers, suppliers. It probably would be prudent to have some kind of policy in place whereby information is not just visibly or accessible to other members that shouldn't have access to it. I think that's pretty much it.
Yeah, that's all the questions that there is for now.
Yeah, anybody we haven't answered, we will go back over the questions, and anybody we haven't answered, we'll get back to you individually, but I think we've covered most of them there, so we hope we haven't bored you too much. And
no, thank you all very much for your attendance. I hope you found it informative and somewhat helpful. So we are recording, as we said, and we'll be sending the link with those extra help sheets later on this afternoon. So thank you very much, and we'll hear from you all again soon.